Number 50, People versus Carr. Counsel, good. You want any rebuttal time?
3 minutes, please, Your Honor.
Okay.
We're here to speak about the court's denial of the defense request for a missing witness charge. I think there are two issues here that are contested. One is the timeliness of the request, and number two would be whether the testimony would have been cumulative to that of the other witnesses. I'll start with the timeliness. Defense counsel made this request on the same day that the people rested, while the defense was still in the midst of putting their case on. The trial court ruled...
Well, that was informally, right?
It was informally, Your Honor.
Yeah.
But
and when did they make it in a formal sense?
Right.
At what time was that?
That was the next day, and it would have been after the close of all testimony.
Does it matter that it was informal?
I don't think so, Your Honor, because the record is absolutely clear that defense counsel raised the issue the day before.
All four of the appellate divisions have held that a request for a missing witness charge that's made at the charge conference after both sides have rested is untimely. Are they wrong?
Well, I think they are, and I'll get into why, but I don't think that this court would have to find that they're all wrong.
You made yours before both sides rested?
It was before the defense rested, after the people rested. But
you know that the people were not going to call this witness much earlier on in the trial.
That's correct.
When did you learn for the first time people were not going to call witness?
That would have been during jury selection when the people handed the witness list. And the court used that as the basis for denying.
Wouldn't that have been a better time, more timely time? People would have had an opportunity to call the witness if they felt it was necessary, rather than just getting a non-favorable inference charge?
At that point, defense counsel doesn't know what the other witnesses are going to testify to, may not even know whether these uncalled witnesses have knowledge about the case that's material. Until he can hear what the other witnesses say, you can't make an argument in a vacuum that a missing witness charge is proper. You need to know if the testimony is going to be cumulative. You need to know if these people were there. You would need to know all of that, and that all came out during the people's...
Apparently they were around, right? They were in court part of the time.
They were in court, yeah.
One of them got involved in some kind of a disturbance in the hallway. And then there was some discussion with the judge, and the people indicated they were not going to call that person, right?
I don't think it got that far.
I think both sides said they weren't, but they didn't intend to call that witness when you were questioning. I guess the judge must have been questioning the juror as to what the juror saw or didn't see, or whether it affected their perception of the case, right?
Correct.
Didn't both sides indicate they weren't going to use that witness?
Yes, and I'm not disputing that defense counsel... I'm not saying defense counsel didn't know, even as early as jury selection, that these witnesses were not going to be called. What I'm saying is that that's not enough to get a missing witness charge, to simply know that a witness isn't going to be called. The witness has to have knowledge about a material issue, has to be in a position to offer non-cumulative testimony. And, the other prong turns on the relations between the parties, but we won't get into...
Do we consider the fact at all that at a certain point it's too late for the people to try to rectify the situation and to go and look for the person and to bring them in to testify?
In this case, they were all spectators at the trial. They were all around throughout the course of the trial. They were family members of this alleged victim, Mr. Marble, family members and friends. They could have easily gotten him, but I think, yes, the request should be made at a time when the people could call him, and that would be before the close of all proof. Because even during the defense case, if they ask for this missing witness charge, the people can say, well...
Why not call him before the people rested, at least before the people rested, so that they could bring in a witness the next day?
Well, and possibly they should have, but I don't think asking for it during the defense case precludes the people at all from calling those witnesses. I think, at least in the Fourth Department, for good cause, the people can put another witness on
Isn't that
after
up to
they've
the
already
discretion of
arrested.
the court then at that point?
It would be, and I think the people's argument will be, well, you know, we didn't know about this missing witness charge, and now in order to prevent that charge, we'd like to call this witness. And I don't think there's a trial court in the world that would deny that. It sounds like a reasonable request.
What would the witnesses have added to the situation?
Well, I guess, you know, what that is getting to is whether the...
No one disputes there was some taunting going on, right?
No, not at all.
So what would they add that, you know?
Well...
You had the videotape, right?
Right. They would give
And
a
you had
perspective
the victim, right?
of what happened and what was said. The victim, Mr. Marble, alleged victim, couldn't remember much of what happened. He remembered up to a certain point, and then he said, after that, I don't remember a thing. So they're not cumulative to him.
I suppose, I mean, I'm a juror. I just heard the missing witness charge, which says you may draw an inference that the witness's testimony would have been unfavorable. What's the inference I draw? What's the unfavorable testimony I'm supposed to hypothesize that these witnesses would have given?
That it would have been consistent with that of Clarence Carr, the co-defendant, that these people were reaching toward their waist, that they were threatening Mr. Carr.
So because you had a video of their movements, so they'd probably be more useful on what they said.
And yes, whether they were making threats to Mr. Carr, which Mr. Carr did testify.
The videotape really showed the weapons and all of that. I mean,
Right, but what it can't show, what a videotape of that quality can't show, is whether someone reaches toward their waist at some point, whether there's something dark at someone's waist. You know,
you could see a lot of that.
it's, you know, it was a better quality video than some, but it's not as clear as a person who was 5 feet away from it.
Apropos of the argument we just had, did anybody make a motion to exclude prosecution witnesses before the people's case?
That I am unaware of, but I'm almost sure that they did. I'm not 100%.
And so when these people were not excused, you then knew that they were not going to be called, so you knew it very early on.
I'm not disputing that the defense knew as early as jury selection that these witnesses wouldn't be called. But again, what I'm saying is that's not enough to make an argument for a missing witness charge. You need to know if their testimony is going to be material, if it's going to be cumulative, and you don't know that until you hear the testimony of the other witnesses and until you see the video, which, you know, I'm assuming the defense saw before trial. But
How does that square with Gonzalez, which says that you make the motion as soon as possible?
Well, as soon as practicable. And I think what you need to do is look at what's practicable. Can I stand there and say to a judge before a trial even starts, Your Honor, I've just learned that this witness isn't going to be called, and I think we're entitled to a missing witness charge. The testimony is not cumulative to these other witnesses.
No, but you could have done it a lot earlier than you did, though, right?
They could have done it.
I mean, it wasn't, you didn't have to wait till the time that you did it. And then again, I come back to the earlier question I asked you. Does it matter that when you did it, which maybe makes a big difference between the time of the informal request and the formal request, do we just assume that when you did it informally that's the same as doing it formally? Because like you say, it's clear on the record that happened.
Yes. Well, I think it puts the concern we have here is that the people are aware that the charge is going to be requested. So it did put the people on notice, it put the court on notice that the request was going to be made. Is it a better practice to put it on the record? Sure. But it did put the people on notice that it was a request that was being made.
Just practically speaking, it probably would have been better for the defense if they all testified, because half the time, you know, multiple witnesses can't keep their story straight.
That's
so why wouldn't you put them on notice as soon as possible and almost dare them to put them on? Because then if they're on, you get that shot.
Perhaps, again, that would have been something the defense should have done. And that's why I think this wasn't a tactical decision to hide the ball and request the missing witness charge late and launch a surprise on the people. What it was is they didn't know whether or not it was an appropriate charge until they heard the testimony of the people's witnesses.
Well, the charge notwithstanding, you could have called the witnesses yourself, couldn't you?
Well, yes, but the control aspect of it goes to the relations between the parties.
Well, you could have directed or asked the court to direct that the witnesses testify.
You could have, but
I mean, they were there. They were in
but
the
these
area.
are prosecution witnesses based on the
No, they were witnesses. I mean,
well, based on the relation between the parties. Clearly, the prosecution would not have been entitled to a missing witness charge had the defense not called these
well, the
witnesses.
defense doesn't have any burden of proof, so the prosecution will have a very difficult time getting a missing witness charge in any event.
Well, they can get missing witness charges in particular cases, but I guess what I'm saying is that it's of no moment that the defense could have called the witnesses. The question is whether they're entitled to get this instruction of a negative inference for the people's failure to.
But I mean, it sort of makes it look as though you were playing gotcha.
Well, and I do understand.
If they really had something to say that you thought would be helpful to the defendant, you could very easily have seen to it that they testified. You could have called them yourself.
Well, I understand that argument, Judge, but that argument, I guess, would go to the propriety of ever giving a missing witness charge. And, I don't know that the court is prepared to, in this case, overrule the propriety of ever giving a missing witness charge in any case. And I think that's what that argument would go to.
Okay, counsel. Thank you. Counsel, go ahead.
It's the people's position that the court did not abuse its discretion when it denied the missing witness charge in this case. First of all, it was untimely.
Even their informal raising of it was untimely?
Even their informal, because he...
Why? What was the problem in terms of your strategy or anything else at the time that they did the informal?
Well, at that point, the people had already rested. The defendant had already called, the co-defendant had testified, and there had been one defense witness. So in the middle of his case, after the people have rested, he's now asking for a missing witness charge.
You could certainly have put on a rebuttal case, couldn't you?
Yes. We could have.
So the fact that you rested is really irrelevant.
No, but as Gonzalez says, Gonzalez says as soon as practicable.
When was the charge actually requested in Gonzalez?
In Gonzalez, I believe it was requested after the people had rested.
Sure it wasn't after the close of all the evidence?
I'm not sure. I thought it was after the people had rested. But in any case, this is not hide and seek. A trial is a...
Okay, well, do you have any case in which a request before the close of all the evidence was held untimely?
No, not that I could find, Your Honor.
So it wasn't, I guess, isn't this kind of hard on this defense lawyer who's doing apparently what everybody else has been doing from time immemorial and everyone thinks it's fine, and all of a sudden someone says he's untimely?
No, but under the facts of this case, this is untimely. He's handed at the beginning of jury selection a witness list that does not list these three people. The prosecutor makes an opening statement where she tells the jury, these are the people you're going to hear from. Those three people aren't mentioned. We call our witnesses. We close. Those three people are not called.
What's the harm to you?
There is no harm. It's just about, well, there is harm because now we have to retailer our strategy. And how about the orderly procedure that the trial is supposed to take?
But how about if we wanted to sort of establish some kind of a rule or, talk about when it's untimely and when it's not? Wouldn't this fit into something that generally would be perceived as timely?
We think not.
If we are trying to set, based on some of these cases, appellate cases, wouldn't it generally be considered timely? Or would it?
I think no. We're asking the timely.
Or is it the particular facts of this case?
The particular facts of this case.
But in general, it would be, right?
In general, no. In general, I think it should be once the prosecutor utters those magic words, the people rest.
That's what becomes
Exactly.
And how the appellate cases along those lines?
There are cases that say that if you wait until after both sides have rested,
I know
that it's untimely. But
what about with the people? Is that generally considered timely?
If it's made at the time that the people say they rest, that's considered timely. It's after that when you move into the defense case, and obviously when you wait until both sides have rested, and you ask for
Gonzalez was during the charge conference after both sides have rested. I just checked the decision.
Okay.
So this would be moving. I mean, we obviously didn't set a particular time frame in Gonzalez. So I think all of the appellate divisions have said then waiting to the charge conference is too late. So you're saying it's got to be moved up to before the defendant starts to present?
That's what we're saying. People rest.
His witnesses?
That's the time. And especially in a case like this. I'm sure that they're going to be
Even though there's an opportunity for rebuttal?
Yes. I'm sure they're going to be...
Why?
Why?
What's the rationale? Even if there's an opportunity for rebuttal, what is the rationale?
Because I think then it throws the people off. We have tailored our strategy and our case a certain way. The court has explained to the jury that a trial is conducted in a certain manner. First you hear opening statements, then the people put their proof on, the people rest.
So rebuttal wouldn't make you whole, really?
No, not really. Because
Okay.
now in the middle of the defense proof, the court is going to say, well, now, ladies and gentlemen of the jury, I know I told you the people rested, but guess what? They're going to reopen their case now, and they're going to call...
I thought what the question was suggesting was not reopening, but rebuttal. I mean, in this case, these so-called missing witnesses would have been perfectly appropriate rebuttal witnesses for you, right? You had one of the defendants testifying as to what happened, and they were there. They could contradict him.
Correct. And, of course, I think it's all speculation as to whether or not, what, if anything, these witnesses could have offered.
Isn't that always true in a missing witness case?
Not necessarily. I mean, they were present in the store, so the assumption is that because they were present, they might have seen something.
But there wasn't that much testimony here.
No, that's true, Your Honor.
I mean, there's the video and there's the victim.
And the victim and the
that's
doctor,
it.
and that was basically it.
So
But
could have been,
I'm sorry.
of consequence, right?
Maybe, but if you look at that videotape, I don't know if the court saw it, once those shots went off, people started to run for their lives. So what, if anything, people saw or heard, we don't know.
Well, it might have been instructive, though.
It might have been, and so the defendant could have called them.
If there was error, was it harmless?
It was harmless in light of the overwhelming proof.
What was the overwhelming? I mean, I understand that the justification defense may not be terrific in this case, but you had to prove intent to kill for an attempted murder conviction. What was the overwhelming proof of their intent?
Okay, the overwhelming proof of their intent was the co-defendant testified, Clarence Carr, that he called his son, the defendant in this case, to come into the store. And we know why he called his son, because of the incident that had occurred earlier. This was basically a revenge attack, at which point the co-defendant proceeded to chase the victim down the aisle with a machete. This defendant, in his statement to the police, admitted shooting 3 times at the victim. He shot him once in the confines of the store as the victim is chased up and down the aisles. And when the victim manages to run out of the store and away from the defendant and falls to the ground after having been shot, the defendant shoots him 2 more times as he lays on the ground.
I mean, you can certainly find intent to kill. I guess couldn't a reasonable jury also have found maybe he was just trying to wound him because if he really wanted to kill him, he sure had his chance. I mean, how hard can it be?
I think bad aim, which he said.
Well, I mean, I understand the argument, but can't the other argument also be made that you can't, that on this evidence you can't tell whether it was whether what was intended was a wounding or a killing?
I beg to disagree, Your Honor. I think if you saw how methodical this man was, the fact that he chased him out of the store and when he was laying on the ground and he could have walked away, after having shot him in the store and his father hitting him in the back of the head and the neck with the machete.
So it's overwhelmingly clear to you this is a methodical guy with bad aim?
Yes.
And the reason you didn't call these people is because they were going to be cumulative?
The prosecutor, when asked by the court, said that he thought that it would have been cumulative based on the victim's testimony and the fact of the videotape. The videotape showed the jury everything they needed to see. Unless there are any questions.
Anything else? No. Thank you. Counselor, any rebuttal?
Yes, sir. Actually, the prosecutor at trial said that he had no information that led him to believe that the testimony of these witnesses would have been cumulative to the witnesses already called. The court asked him specifically, and he said, no, I have no reason to believe it would be cumulative. Second, the people were not harmed by the alleged untimeliness of the request. The people at the trial level never even raised the timeliness issue. The court did. On appeal to the Fourth Department, the people conceded that the request was timely. It's in their brief on page 9. They cited a case in support of it. So they were never harmed by this. They never saw it as a harm. They latched onto what the Fourth Department's rationale, and they're now using that to argue. And as far as the harmless error goes, in a case like this, it's only harmless error if there was no significant probability that the jury would have.
But I want to go back to the fact that you're asking for a missing witness charge with regard to a witness over whom you had as much control as the people. You could have called the witness yourself.
Well, availability and control are two separate concepts. The witnesses were equally available to the defense and the people. That doesn't matter. The only requirement is that they be available to the people. As far as control goes, control depends on the relations between the parties and which side the witnesses are expected to testify favorably towards.
Notwithstanding the side, though, you had the court there to enforce that request, the judge himself.
To enforce?
To direct that a witness testify.
Well,
or be produced to testify.
The judge could request that.
Not request.
Or
direct.
Oh, yes. But that's what a missing witness charge is when the people fail to call a witness and the defense asks for an inference based on that. It's not that the defense is saying.
But that presumes that the witness is unavailable to you.
That's not true, Your Honor. The way this court has ruled is that the moving party must show that the witness is available to the people, not that the witness is unavailable by subpoena or by other means to the moving party.
I guess the defense counsel determined that they'd rather have the inference than have these people testify.
Well, not necessarily. They'd rather have – they wouldn't want it to be their witness. Because
there's a difference between calling him as your witness and letting the people call him.
Correct, yeah. You can't cross-examine your own witness. You can't impeach your own witness.
Yes, you can. You can certainly examine him as a hostile witness.
You could, but I think we're getting into things right now that would undermine all of the jurisprudence surrounding a missing witness charge. If what you're saying is true, Your Honor, that would go to any case where a missing witness charge is ever asked for. Yes, you could always the judge could always compel somebody to call a witness, but the law has evolved in this way for a reason, and toward the missing witness charge request and instruction.
Thank you. Thank you both.